Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 24th of February 2025, the defense filed motion in limine number 6 seeking a ruling pre-trial, which is what an in limine motion seeks, ladies and gentlemen. This is entitled regarding Rylene Nowlin and reference to touch and contact DNA. If you have not yet had an opportunity to review the recently released redacted transcript from the closed hearing on the defense's motion to suppress evidence citing to the Fourth Amendment of the United States Constitution and the Idaho Constitution and other legal grounds, please do so. That transcript, which was released to the public recently by order of Judge Stephen J. Hippler, goes into testimony provided by several key figures in the case, including Rylene Nowlin, who stated that she was a manager of the Idaho State Police Forensics Lab. So please read up on that transcript. It will provide you with further details. What is the defense asking for here? They want an order in limine excluding the testimony of Ms. Nowlin and any testimony, and there's 2 points here starting at the bottom of page 1, going into page 2, referencing the terms, quote, touch or contact. Touch or contact DNA, go to the next page. Or 2, purporting to be an opinion of the means or mechanism for DNA being placed on the sheath by any witness called to testify about DNA. What is this about? Well, the defense says both the terms touch or contact DNA or any opinion regarding how DNA ends up on an item is misleading in that it assumes facts that must be proven, would be confusing to the jury, and waste substantial time in debunking the testimony of an expert that is outside the purview of the field expertise and qualifications. Furthermore, the opinions of this expert has not been disclosed to Mr. Kohberger. As set forth below, the how and when of DNA arrives on an object cannot be scientifically determined according to the defense, ladies and gentlemen, and is not the proper subject of expert testimony. So what the defense appears to be arguing here is that this is a classic case of quote-unquote junk science that may not be permitted to be included at trial for the jury to hear because it's unreliable and on other grounds, including what the defense argues in the next paragraph, that this language confuses and misleads the finder of fact. That, ladies and gentlemen, will be the jury. The jury is the finder of fact at trial and is barred by rules 402 and 403. These are rules of evidence in Idaho, as well as due process that's guaranteed by the 14th Amendment to the United States Constitution, in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process. When it renders a trial fundamentally unfair, they cite to Estelle versus McGuire, 1991 United States Supreme Court case, citing to the U.S. Supreme Court because they are now citing to the 14th Amendment due process clause, and the Supreme Court is the ultimate and final court in the country that interprets the United States Constitution. Now, ladies and gentlemen, this sheath, which was, as we learned in this case, including starting from the affidavit of probable cause, is a key, possibly the key, evidence against Mr. Kohberger. Now, we have to say that knowing that so much evidence is still under seal. But because of this, we are going to offer another review of this filing on our YouTube channel, which will allow us to go into a little bit more detail and provide you with some of the information. And there's graphs in this in limine motion. In the interim, you can read it for yourself. Go to the Idaho cases of judicial interest, go down to the 24th of February 2025, and you will see it there. We now await the state's response to this in limine motion, which is due on or before March 17th. This is Kathy. Thank you for joining us here today.